rise.
I've got no manners. Right.
So, my lord,
Yes, we are, I'm afraid, starting without the transcriber. I was willing to give her 5 minutes.
there's a horrific queue, apparently.
So I gather. Well, these things happen. I think you could be encouraged if it happens again to pull rank and say it's required in court. But,
You asked me for a list of references for
Yes.
other eye conditions being treated with wet AMD, and we've done our best in the time available to give you some of the references to make good that point evidentially.
okay.
One needs to be careful because wet AMD is not the only eye indication for which Lucentis and Eylea are indicated. There are other eye indications, but there beyond that are further eye indications for which there is no licensed medicine indicated for which CB may be used. Can I pass that up and a second note which just puts in one place all the references to show how, so far as we were aware, historic supplies of CB to the market were for the treatment of those conditions or using specials powers, and that's included the period before Eylea received its marketing authorization. So CB was widely used before there was any licensed indication as an Article 5 special at that time. So hopefully that's the speed of the pen. There was also one other point those behind me were keen that I should re-emphasise because they detected some confusion, which is my fault. The survey of manufacturers undertaken by the MHRA was not a survey, as we understand it, exclusively of commercial manufacturers. We don't know the identities, but we think within it, and maybe Mr. Peretz can confirm, there was a good proportion, if not a majority, of NHS manufacturers. And that would tally with, and he confirms that's correct, that would tally with paragraph 30 of Mr. Hambleton's evidence. If you recall, he identified 4 NHS manufacturers and just 1 commercial manufacturer, ITH.
But those NHS, when you say manufacturers, presumably mean the pharmacies.
No, they may be manufacturers, my lady, because they have specials licenses.
Right, that was going to be my next question.
Yeah.
They have pharmacies with specials licenses.
Exactly. So we were going through Apposite, and I'm going to try and get through this as quickly as I can in IFA so I can get to my submissions, which will hopefully run quickly, given how carefully we're going through these cases. And the next place to go after the famous paragraph 42 is paragraph 43. So Authorities Bundle B, tab 23, page 571. Because having set out these 2 conditions, the court then addresses Aventis, which was the focus of argument, addresses Aventis and distinguishes it on the basis that here the activity undertaken by a company like Apposite occurs after the medicinal products in the main proceedings have been placed on the market. So it seems to be, by contradistinction to the Advocate General, applying some kind of exhaustion of rights type analysis. But they then go on to say, and this is significant because this is why we say the prior prescription requirement must be the same. In particular, the drawing off the liquid medicinal products from which the original vials and the transfer into ready-to-use syringes of the portion so drawn off, without any modification of those products, is in reality analogous to actions which, in the absence of Apposite's activities, could otherwise be or have been carried out under their responsibility by doctors prescribing the treatment or by pharmacists themselves in dispensaries or else in hospitals. So what they're saying is it's analogous, the activity, to that which you can do under Article 3. And if that is the case, it can't be that the prior prescription...
Is that necessarily what they're saying?
Or that's how we read it, my lord.
It occurred to me when I read it before that they might be saying that in that situation Article 6 wouldn't be engaged because there'd be no placing on the market.
Well, if they're saying it's in relation to single vial use, then that is use and administration. But obviously that's the problem with this analogy. The analogy breaks down once you move away from single vial use. Because
By single vial use, you mean mode 1?
Mode 1,
Yeah.
exactly. That is, to an extent, analogous if that's all that you're doing in the pharmacy. The problem with this line of reasoning, which, to be fair, I don't think the CJU has recognised or grappled with, is that in what we call modes 2 to 4, it's not at all analogous to what happens when the doctor administers treatment, because there is the application of a prior manufacturing process to do the aliquoting, which in our regulatory regime, as you've seen, is entirely impermissible for the doctor to do. The doctor is prohibited, unless using a manufacturing process, is prohibited from taking more than one dose from the vial. So the analogy, with respect, is a dangerous and unsafe one.
Well, all right, but I see that, but I'm just trying to see how the analogy, how that observation actually plugs into its reasoning.
Well,
And okay, they say it's an analogy. You say it isn't a good analogy, but they say it's an analogy. If they're right, why would it follow that it was lawful?
why would it follow? It's not that they follow that it was lawful. It follows as to why they've imposed a prior prescription requirement, which is analogous to the prior prescription requirement that would apply under Article 3.1. Because if it's
It can't
done...
be Article 3.1 because it's not a pharmacist. It's not a
No, but what they're saying, my lady, is it's analogous to that which a pharmacist can do. And that which a pharmacist can do is to compound pursuant to a prior prescription.
Well, you see, but the thinking is, if you look at the end of 42, the conclusion is it's not subject to the obligation to hold a marketing authorization granted pursuant to Article 3.1 of the regulation.
If the two conditions are met.
Yes, all right, but I see that. But and that is essentially, we might have to check, to do with marketing or placing on the market.
Yes.
So is what they're saying in the second half of 43, if all that's happening is the doctor is doing something, as it were, within the hospital or within the dispensary, they're not placing anything on the market?
Well, they can't be saying that, my lord, because,
Well, tell me why.
because that would negate the very purpose of Article 3.1 to begin with. There would be no necessity for that if that type of activity didn't involve a placing on the market. So there would be no need for the exemption in the first place. And that's particularly true for 3.1. It's also true for 3.2. And equally, it would mean that effectively, as long as manufacturing of medicinal products occurred in-house by the party supplying treatment, it would be entirely outside the regime of the directive. That would be an enormous lacuna. Because on your analysis, if you're simply you make the product and then you simply supply it to the patient, there's no placing on the market.
Yeah, well, I'm not saying it's easy, but I'm just trying to see what, or even that it's right. I'm just trying to see what they were thinking.
Well, I mean,
You say they can't have been thinking that because it's...
let's be candid about this. None of this is particularly clear. It's not exactly, I'm afraid, clear or crystal clear high quality jurisprudence. It's the law being made on the hoof and making a pretty substantial change on any view from the logical and legal purity of analysis, which is, I would suggest, that contained in the Advocate General's opinion.
Well, the reason why they seem to be saying that the doctor prescribing the treatment or the pharmacist doing the activity in their dispensary, why they regard those as not being unlawful may be different. There may not be the same reason for those two things being being lawful. So the doctor prescribing the treatment, is that the idea that the administration of the drug is not a placing on the market and therefore not unlawful?
Absolutely.
Yeah.
And
And just wait a minute.
I'm so sorry.
The pharmacist is not administering the drug. The pharmacist would have to then be taking advantage of Article 3.1.
Well, it comes down to, in my submission, a conflation between modes 1 and 2 to 4. Mode 1, we've accepted the pharmacist, the doctor simply drawing out of the vial and injecting in the patient's eye is not a new placing on the market because there is no product made. And that we accept therefore, is not a relevant placing for the purposes of looking at Avastin. But the minute you manufacture the product, you're outside the boundaries of use and administration. I go back to the original theme I introduced with this case. It's a very important difference. Once you've applied a new manufacturing process, you have to look at the use and administration of the product produced by that manufacturing process. And what they've done, in my respectful submission, is unfortunately conflate mode 1, which is use and administration, and therefore not a new product, as we've accepted, and modes 2 to 4, where there is a new product created. It may be stored up to 7 days or 90 days or what have you, and then that product is used and administered by the doctor who injects it into the patient's eye.
Obviously that's all very elegant and may well be what the law ought to be, but I'm still not persuaded that that was how they were applying it. I'll just put one more point to you and then I'll shut up so we just think about these things. But the in particular immediately follows the observation that in Aventis, that the distinction with Aventis is the activity was carried out after the products at issue in the main proceedings had been placed on the market. And that again just seems to suggest that, however you would say wrong-headedly, they were saying that providing you don't modify the product in the way they seem to be talking about modification, the wrong way you would say, you aren't placing it on the market. It's, as it were, just moving it from one person in the system than the other.
I understand.
But if that is what they're thinking, aren't we stuck with it and have to make the best of it?
Well, no, for this reason. The test is still the test in paragraph 42. All that paragraph 43 is relevant to is understanding what it is that they're analogizing and what it is that they're effectively saying is the basis for distinguishing the reasoning in Aventis.
Yes, but it helps to explain the conceptual basis of what is said in 42.
Yes, well, what is being said in 42 is if these conditions are met, then subsequent handling of a product so treated shall not be treated as a further placing on the market. The clear implication is if the conditions aren't met, they will. So if you modify and supply without a prior prescription, that is a further placing on the market. That's inescapable logic. And the reason they're saying the prior prescription makes a difference is because that process is analogous to use and administration in the hospital. And that's why I say it does explain the utility of the prior prescription condition.
Right, and the point about it not being modified is that then is what enables them to say that the medicinal products at issue have been placed on the market because
That's
they are
right.
assuming that this is not a new product.
That's right. So, that's 43. However, there is still a very large sting in the tail of this case. 44. It should be observed that even if the service provided by a company such as Apposite to its customer pharmacies does not in itself amount to placing on the market, requiring an MA, that nonetheless does not mean that the activity is lawful, since it remains in any event subject to the provisions of the directive, in particular the provisions laying down a requirement for an authorisation to manufacture medicinal products. Now you remember in the Advocate General's analysis, the analysis in relation to a manufacturing licence is superfluous because she's already decided that you fail at the level of the marketing authorisation. Under the court's analysis, it becomes a mandatory area of investigation because what they are accepting is that manufacturing is occurring. And what that then takes you back into is an analysis of the application of Article 42 bis. And after the German government's vain attempts to invoke Article 5 at paragraphs 45 to 48, which don't apply, you get the analysis on that topic over the page. By the way, paragraph 49 at the top is again entirely consistent only with prior prescriptions being a requirement, hence the reference to the ABPI case. And then 51 to 53. With regards to the requirements of Article 42 bis, it is indeed the case under the first subparagraph of the directive, authorisation, marketing, manufacturing authorisation is referred to in that provision, is required for that activity insofar as it concerns, and here's the word repackaging again, the repackaging of medicinal products which have a marketing authorisation. It's further proof that the focus of the debate has only been the Aventis type repackaging and not factors going to the quality of the product. And then, however, as Ireland and the Commission submit, it's possible for such authorisation to be obtained in relation to dividing up and changes in packaging where those processes are carried out solely for retail supply by pharmacists and dispensing pharmacies or by persons legally authorised to carry out such processes. And then 53, again this is critical for ground 2, it will thus fall to the referring court to ascertain, in particular, on the one hand, whether Apposite is legally authorised in Germany to carry out such processes, and on the other, whether those processes are in fact included within a system for the retail supply of medicinal products by the pharmacists. On the latter point, the referring court will have to, in particular, determine whether the processes in question are carried out only on the basis of individual prescriptions that call for them to be carried out. So even if there isn't an individual prescription requirement from paragraph 42, you are immediately driven back to it in the court's way of interpreting Article 42 bis. It equates, and this is what we've said, it seemingly somehow equates supply pursuant to a prescription with retail supply. That seems to be the loose test that the court is applying here. Then you come to the dispositif, and you have to look at that because the judge below decided that it was no part of the ratio of this case that there were prior prescriptions. That is a conclusion impossible to sustain against the dispositif. The dispositif says activities such as those at issue in the main proceedings, provided that they do not result in the modification of the medicinal product concerned and are carried out solely on the basis of individual prescriptions calling for such processes of such a kind, a matter which falls to be determined by the referring court, do not require a marketing authorisation. And that reflects the content of paragraph 54. So there is a mandatory inquiry for the national courts into the question of modification.
But and it doesn't deal with whether they require a manufacturing authorisation.
It says that the inquiry, in effect, that's what paragraph 53 says, you have to check whether or not national law has made use of the facility to provide an exemption under 42 bis, and whether or not the activity falls within it and amounts to retail supply. That's the only way you can read paragraph 53.
Yeah, I suspect, and maybe wrong about this, my lady's point was that the dispositif doesn't say anything.
Oh, the dispositif, I'm so sorry, yes, that's quite right. Yeah. Yeah, but it's still clearly the reasoning of the court as to how you're going to get over the manufacturing licence requirement. So what you have as a result of Apposite is 2 EU law requirements to investigate the prior prescription. You've got paragraph 42 and you've got paragraph 53. And we shall see nothing in IEFA changes that analysis. So IEFA is in the next bundle of authorities. Bundle D, B, C, C.
I can just mention something to the transcript writer. I know you've had problems getting in. I suspect it will be possible, but you'll have to talk to those who are instructing you, which isn't the court, to pick up the missing minutes off the live stream. But they'll help tell you how to do that. It'll be helpful to have the whole thing. Thank you.
IEFA, Novartis Pharma SPA, is a case referred after Absur was decided and after Apposite was decided. So with that case law before the National Court, before it made the reference. The relevant setup in Italy you can see in particular from paragraphs 18 and following. And in particular, I'm so sorry, it's tab 29, page 713 of the bundle pagination. It's a case that starts with reimbursability. The first step along that line, paragraph 24, is that the relevant Italian body, the CSS, issued an opinion on the use of Avastin in ophthalmology, which stated, inter alia, that the preparation of that medicinal product for intravitreal use is a sterile magistral pharmaceutical preparation. That's Article 3.1.
So the CSS is the equivalent of which English?
I don't know the immediate answer to that, my lady. I will find out for you. I'm sure a note will be passed to me. Consiglio Superiore di Sanità, so the Superior Health Board, whatever that might be.
Yes, I didn't ask what its translation was. I asked what English
I'll-
body it's equivalent.
I'll find out. Forgive me, my lady. What? Right. It's a bit like monitor. That's probably not much of an answer to my lady's question.
Well, only if it assists. If it's the price setting body which determines what prices will be reimbursed in the Italian insurance system, the nearest equivalent we've got here is Monitor, part of NHS Improvement, which sets the prices for a national tariff under the NHS standard contracts which exist between clinical commissioning groups and hospitals, which govern how much they get paid for each procedure.
Is that the successor to some previous body?
My Lord, Monitor still exists as a legal entity.
What was it before?
Before it was the Department of Health. And now Monitor is encompassed into a wider organisation without statutory framework, which is known as NHS Improvement. But there is a body which essentially sets prices for a hip replacement or a eye drug procedure, and that's, I think, the nearest we've got, though it's not precise.
There is some light cast by paragraph 2, my lady, out of the reference, ordered reference. So the dispute is with the Consiglio, CSSS, and it shows the essence of the dispute is about the entry of the medicinal products used off-label for the treatment of eye diseases onto the list of medicinal products reimbursed by the Italian Health Service. So it's the body that controls reimbursability, in another word. And as I said, this case starts with a dispute about reimbursability. And the first step is that effectively a magistral formula is set. Now, a magistral formula is an Article 3.1 scenario. And what's interesting about this case is, notwithstanding apposite, etc., the questions as referred are all about Article 3.1 and not about the apposite exemption. Because what has happened in Italy is that the Italian health system has set itself up for the hospital pharmacies effectively to make the product in-house.
Did you say that the reference, obviously not the decision, predated
Yes.
apposite? Yeah.
Yes, you can see
I'm
that.
not sure I picked that up. Yeah.
You can see that, my lord, from 36, 37 and 38. So there was argument before the reference about the application of Novartis Pharma, etc. But the questions that the court referred weren't about the apposite exception, and they weren't about the question of modification. They were all about the interpretation of Article 3.1 of the directive. And that's because the Italian setup looked like a setup of systematic use of the Article 3.1 exemption. And that's why question 2, which is the principal one of relevance for this purpose, is all about the limits of Article 3.1. Do you see that, my lord? Page 714.
Sorry, I don't, because I was just checking something. Yes, sorry, I just asked a factual question. I'd obviously misunderstood what you said earlier. The reference didn't predate apposite. The apposite was decided in 2013.
Post-dated it. Post-dated it, that's what I meant to say. That, I must have
I see.
misspoke. What I meant to say is the reference was formulated with apposite and the case law plainly in mind,
Yes, I see.
and notwithstanding that, the question was targeted on Article 3.1. You see, Novartis Pharma
Okay,
was...
now we've cleared that up, I understand. So, okay.
Yeah, so question 2 is all about Article 3.1 and the limits of it. There's then a dispute about admissibility that we can skip over. Articles 47 to 52 are yet a further answer to the EU law stops at the doors of the NHS argument in all its variants as advanced by Mr. Locke, and effectively says, notwithstanding all the same case law he relies on, Menarini, etc., this case is all about whether or not you can, consistently with the directive, lawfully make and place on the market these products, and it's not about the state's discretion in relation to reimbursement.
Which paragraph are you?
That's 47 through to 52, my lord.
Yeah, thank you.
And then they turn to the second question, the Article 3.1 question. And the first surprise is that they say that these operations, and this is the net upshot of everything between 53 and 65, is that these compounding operations can't fall within Article 3.1 if the product in question has not been modified. And their reasoning is that if the apposite exemption applies, the product in question hasn't been modified, and therefore you can guarantee the continuation of pharmacovigilance obligations in relation to what is already a licensed medicine. And in reaching that analysis, the key in my submission is paragraph 58, which recites their understanding of the setup of the case from the facts on the file. It's clear from the facts on the file before the court that the process for repackaging Avastin, undertaken in accordance with the national measures at issue in the main proceedings, does not significantly change the composition, form, or, and then this is the only language I found that somehow casts a light on what the modification test may be, other fundamental characteristics of the medicinal product. Those repackaging processes cannot be regarded as the preparation of a new medicinal product derived from Avastin by means of a magistral formula or an officinal formula. They therefore do not fall within the scope of Article 3. So that conclusion is reached on the basis of the facts in a case where the question of modification is not even being argued, because the case has been set up to argue about the limits of Article 3.1 and compounding. And the logic of the passage through to 63 and following must be that if there is, on the facts, a modification of the product, then you are thrown back into the arms of Article 3.1 as your only last card to play. That must follow logically. They're saying there's no modification and a prescription, and therefore you're still within the scheme of the directive. If there is a modification, it must follow logically that then the only show in town is Article 3.1.
Paragraph 59 seems to be the opposite of the argument deployed by the Advocate General in Avastin.
Yes, you're quite right, Madam. What's happened is the entire original purpose of Recital 35 has been completely lost. Recital 35 was the justification for ensuring control over the wholesale dealing system. That was its rationale. It introduced a whole new wholesale dealing regime taken over from Directive 92/25 that Advocate General Sharpston referred to in paragraph 8 of her introductory section. And yet it's now being used for a completely different purpose, whose effect, if taken too far, ironically, is to remove any of the requirements in the wholesale dealers system to deal only in licensed and authorised medicines. It's quite strange, I accept. So that's the first passage, and then they answer the first question at 66 and following, and the structure is, in effect, apart from this salvoing of Article 3.1, is exactly the same. It's the apposite test recited, including the test for whether or not there is a modification and prior prescriptions, which are questions of fact for the National Court. And there's a reiteration that whatever manufacturing processes are used must be for retail supply, must have prior prescriptions. And then additionally, there is language in 75 that says that it must be, this is in relation to manufacturing, undertaken by pharmacists for that medicinal product to be administered in hospitals. So you see 73 is a recitation of the Aventis case, and Mr. Peretz has quite rightly pointed out there is a typo. The word prior is plainly wrong. It's en aval de in French, or en aval, avale de in Italian, which means following on from or after. So it should say takes place after. So it is consistent with the contents of paragraph 43. It's avale delle in the Italian, which is the official version, and that means from my times at the EUI, my Italian finally comes in use. It means after. And then you see reapplication in 74 of the key paragraphs 42 and 43 in Novartis Pharma. Re-emphasis again of this, it's in reality analogous to actions which in the absence of another undertaking's activities could otherwise be or have been carried out under their responsibility by doctors prescribing the treatment. And then subject to factual findings to be made by the National Court, the repackaging under the conditions laid down in the national measures does not therefore require an MA to be obtained. And then you could put 1, so far as the process is prescribed by a doctor by means of an individual prescription. They've reversed the order here. And then 2, if you like, undertaken by pharmacists for that medicinal product to be administered in hospitals. So they seem to have tightened up the definition. 76 then reverts to the analysis of Article 42. And once again, just like the Advocate General, just like the court in Apposite, they emphasise that 42 only applies solely for retail supply of the medicinal products by pharmacists and dispensing pharmacies, or, and this doesn't apply in the UK because it hasn't been implemented, by persons legally authorised in the member state to carry out such processes. It follows that, they emphasise, that where those manufacturing processes are not carried out for such purposes, i.e. for retail supply, pharmacists are not exempt from the requirement to hold a manufacturing authorisation, and they cite Corona. And 77, again, emphasises the need for findings of fact about Article 42 bis. They said those pharmacies could nevertheless fall within the exception, subject to findings of fact to be made by the referring court. It must be held that if it's found that, in accordance with the national measures at issue in the main proceedings, Avastin is, on the basis of an individual prescription, repackaged to be used off-label, etc., by a pharmacy lawfully authorised to that effect. For that purpose, the medicinal product to be administered in hospitals. Those 3 conditions re-emphasise such process falls within the exception in the directive and does not require a manufacturing authorisation. So,
The exception there being Article
2 bis. Where does that take us? Ground 2. Prior prescriptions. Now that I've been through those cases, I hope in not too painstaking detail, you can see that there are 3 sources for the requirement for a prior prescription. It arises as a matter of compliance with paragraph 42 of Apposite, as applied by IEFA paragraph 74 to 75, in order to avoid having to have a fresh marketing authorisation. It separately arises as a matter of EU law as the basis for complying with the gateway to avoiding having a manufacturing authorisation. That's Apposite paragraph 53, applied again in the passages I've just shown you in IEFA 76 to 77. And we say, necessarily, because those are gateways, you then have to look at the national law provisions, and the national law provisions are section 10(1)A of the Medicines Act.
So this is all part of your second proposition, is it?
Yes, this is all ground 2.
No, so sorry. You said.
No, this is the third. You're quite right. So the second proposition is you need it to avoid as a matter of EU law the need for a manufacturing authorisation. And the third proposition is that when you turn to the domestic provisions themselves require prior prescription. And you've seen the GPC document that sets out in the NHS just what that means. You've seen the MHRA guidance.
Do you mean say GPC or do you
I mean the RPS. Sorry, I keep on doing that. Do forgive me. The RPS document that sets out what that means. You've seen the MHRA guidance on the borderline between specials and Section 10 of the Medicines Act, and that, if you recall, emphasised in terms you need to have the prior prescription in your hand. Do you remember that second set of guidance I showed you this morning? Does my lord recall it? Would you like to see it again? No. And therefore one has to ask how it's possible to conclude that this is anything other than a mandatory requirement if the product in question is not to be treated as an unlicensed medicinal product. It plainly is. It's plainly part.
On your analysis, we never get to 3. 3 only arises, or it's not like we never get to it, but it's redundant. 3 only arises if you
I've lost both 1 and 2.
yes.
It is belt and braces, but it's pretty.
Right,
it's pretty
because
darn clear.
the domestic law implementing 42Bs can't go wider than that.
That's right.
And you say the width of that potential derogation is limited by, is it by a fear that says it can only extend where there's a
That's right, my lady.
prescription.
And that's why, if you recall, when I took you through Section 10 of the Medicines Act, I said the only provision in Section 10 of the Medicines Act that can be relied upon is Section 10(1)A, because it's the only one that complies with the prior prescription requirement of EU law. Anything else that authorises you to manufacture stock in advance or matters of that kind without a prior prescription doesn't comply with the strictures of EU law. And to that extent, the Medicines Act can't be relied upon. And this is a point we made below.
I mean,
because
it would be, I suppose it is, of course, theoretically possible. You're right to cover it. It would be very odd to say that that in circumstances where we had found that there was no need for a prior prescription on your first or your second reason, you then will ever need your third.
it wouldn't be odd with respect, my lord, in these circumstances. Suppose you concluded, God knows how with respect, that it wasn't a requirement either of 42 or 43, because the language is as plain as can be. But suppose you concluded that there wasn't an EU law requirement for prior prescription. At the very least, Section 10 of the Medicines Act is the domestic implementation of the retail controls. And so it would arise for consideration in and of its own right.
In this country.
In this country.
Yes.
Exactly.
Your challenge then becomes a domestic law challenge.
In those circumstances. But I squarely put my weight behind paragraph 42 of Apposite. On this point, it is clear. It's plain as a pikestaff. The MHRA agree with us. Absolutely. There is no getting out of that. Because anything else, as the MHRA points out, simply allows you to do wholesale dealing and all manner of other things in relation to what is otherwise an unlicensed medicinal product with no control over it whatsoever. And the requirement of a prior prescription focuses in and provides the supplementary clinical controls that are required in these circumstances. Now, the only other point that one needs to consider before we look at how the judgment deals with it is what exactly is, as a matter of EU law, the content of the requirement of a prior prescription. And you have my point that it is, as explained in ABSA, as I took you through, that requires effectively the prescription to be provided in advance before the compounding is begun for the particular patient. And we rely on all the passages I showed you in relation to that. But once again, even if it's not clear from ABSA, you have to go back to the domestic provisions, particularly for modes 2 and 3, because the RPS document, enforced by EL 9752, sets out all of those exacting requirements about what prior prescriptions mean. So how did the judge deal with this? Core Bundle A, tab 9. and it's paragraphs 120 to 122. The judge concluded at 120 that there was no requirement for, as a matter of EU law, for any prior prescription. And her reasons are as follows. Roman 1, the issue being addressed at 42 is whether the medicines have been modified in such a way that a marketing authorisation is required. The existence or not of a prescription is not logically relevant to the question of whether the product has been modified. Well, two answers to that. First of all, you can't, with respect, ignore the plain language of both paragraph 42 and paragraph 53. She didn't have the benefit of IEFA, but once you've got IEFA, again, you can't ignore them. And prior prescriptions and prescriptions as a safeguard is embedded everywhere. It's embedded in the dispositif as something the National Court has to check for. So even if there were a criticism of logicality, I put back to Lord Justice Underhill the point he made to me, whether it's illogical or not, it's what it says is required. But the second point is, with respect, we don't accept that it's illogical. I've explained to you why it is, on an understanding of modification that is confined to repackaging, entirely logical to insist upon a prior prescription, because the prior prescription is the surrogate protection that ensures appropriate clinical use. It's the surrogate protection for the packaging and leafleting and presentation concerns addressed by the product get-up in the marketing authorisation. And as you've seen...
Hang on 1 second. Yep. You go on.
As you've seen, the poles of debate in Apposite were about repackaging at the one hand, the Aventis case and all that went with it, and compositional changes at the other end. And what is unaddressed is the bit in the middle about quality, which is one of the key focal concerns of the marketing authorisation. And all the language in Apposite that I showed you is in terms of repackaging. The submissions of the national government are about repackaging. The response is about repackaging. The language of Article 42, as summarised by the court, is all about repackaging. And we say a prior prescription substitution for those packaging protections makes total sense. So that's the judge's first point. There's no stated requirement within the directive for a prescription to be in place before the medicines can be supplied for off-label. Well, with respect, that's to ignore what is really going on in the case. The case is a court-made modulation of the rigours of Article 6, and the court has set out some conditions that don't appear in the directive. The word modification appears nowhere in the directive. That too is completely new. So that, with respect, is not a good reason. The CJU does not suggest at 42 or elsewhere in its judgment that it's intending to read in such a condition. Well, it does, with respect, do precisely that, both at 42 and 53, and in NAIFA, the passages are identified, and it directs a factual inquiry as to whether or not that was indeed the case. So, with respect, that can't be right. Medicines which are intended for off-label use will in many circumstances be requested on prescription simply because they're not available off the shelf for use in the manner intended. That is not a universal defining condition of off-label use. It's just an incident of fact. Well, that may be true, but with respect, it has nothing logically or legally connected to do with the reasoning process of the court and the conditions that the court has laid out. And then in Apposite, the German court relied upon Article 5, and Article 5 requires in terms that the medicine is supplied on prescription. That provides a satisfactory explanation to the fact the individual prescriptions were provided in the case. With respect to the learned judge, that's very difficult to follow. The German government advanced an alternative argument based on Article 5. Article 5 is not based on prescriptions, it's based on specifications, which is an entirely different concept, as Absur shows. And that argument was rejected by the court. So whatever may explain this, it has, with respect, nothing to do with Article 5. For those very simple reasons, we say it is plainly wrong to conclude, as the judge did, that there was no requirement for prior prescriptions, and we take great heart that the Secretary of State agrees with us in relation to that. And on one level, that's enough to dispose of this case, because it is entirely clear throughout that no thought has been given by the defendant CCGs to the implications of that requirement. They have consistently rejected throughout the legal case that there is any obligation to have prior prescriptions in place. They have vigorously contested ground 2 throughout, and indeed we produced a note before prior prescription was required, and Mr. Locke said it wasn't. It's a fundamental feature of the legality
not
of the
asking to be taken to it. Where did you say that was?
Bundle B, tab 30, my lord. Supplementary bundle B,
Yeah.
tab 30. And you have my basic point that once you realise a prior prescription is required, and once you realise that the RPS document makes that a very burdensome process, requiring clinical scrutiny, record keeping, and the like, access to the patient's records to check clinical appropriateness, etc., organisational policies to facilitate that, it's not only massively costly and burdensome, it's something that has to be established clearly in advance before you create a policy of this kind. Now, what does Mr. Locke say in response to all of this? You can pick that up in his original skeleton at Core A4, page 91. Paragraphs 39 to 56. The first answer he gives at paragraph 40 is that this is some kind of pleading point, that we never raise this, and you only have to go through our supplementary note that we put before the court to see that it's completely unsustainable. The issue was extensively ventilated before the judge, which is why it found its way into the judgment. Paragraph 41, he says the simple answer is it makes no difference because the trust could set up systems to comply with the requirement. There is no evidence to that effect. All the evidence suggests that that was not in contemplation. All the evidence shows that what was in contemplation was mode 3 and mode 4 by way of wholesale. Indeed, you'll see his skeleton makes that point shortly thereafter. Next point, has the CJE ruled on this point? He points you to the AGCM case, a competition case that in no way addresses these issues. I'll let him try and explain how that case, which is directed to questions of market substitutability, has anything to do with the regulatory requirements clearly identified by the court in Apposite and reiterated by AIFA. It's a rank bad point. Paragraph 43, is the distinction between retail and wholesale supply of drugs relevant? They say we attempt to rely on a new point, namely that the distinction in the directive between wholesale and retail supply, and suggests that it can be equated to medicines that are supplied with or without an individual prescription. So a slight mischaracterisation of what we're saying. What we're saying is that insofar as the requirement for a prior prescription is being used in Article 42 bis, it is plainly being used as a proxy for the supply in question being retail supply, because that is the only form of supply that is permitted under Article 42 bis. You cannot get a national dispensation for manufacturing for wholesale supply, the case law shows. And we say that the reason why the court uses the language of prior prescriptions in relation to Article 42 bis, which does not appear in the language of the directive, must be because they're treating it as some kind of proxy for retail supply. And that is a perfectly fair point to make. It's not a new point in any event. And then they say at 44, effectively, that what they're contemplating was wholesale distribution. And they go through all of the provisions in relation to wholesale distribution that I showed you in opening, and make a series of correct propositions in our submission. In particular, C, an NHS hospital pharmacy does not require a wholesale dealer's licence in order to provide POMs from the pharmacy to its own clinicians. That is correct. Though, of course, it does require one to supply it to another hospital trust. And then they say at D, well, anyone supplying Avastin to an NHS hospital on a wholesale basis would require a wholesale dealer's licence. No reference has been made to it and there's no evidence. Well, two answers to that. There's no evidence because they haven't told us who the suppliers are, so we can't know whether or not they've got wholesale dealers' licences or not. But actually, whether or not there's a licence or not is irrelevant. It's legally irrelevant because the provisions of EU law and domestic law that I have shown you preclude a wholesale dealer from dealing with a product other than in full accordance with its marketing authorisation. And if you follow the logic of Apposite and the market authorisation has not changed, it's impossible to comply with at the wholesale level because you're supplying something in completely different packing, for a completely different indication, etc., etc. And this was one of the paragraphs that got us thinking about wholesale dealing. So that's not a good reason. Does EU law require an individual prescription before CBE can be supplied to an NHS hospital or within an NHS hospital? They say we seek to derive this from Apposite, but again their answer is AGCM, so I'll let them explain this. But they go on to say somehow that any such requirement in relation to the National Health Service would violate their favourite provision, Article 91687. We simply don't follow that as a matter of logic. If it is a requirement that flows from the directive, in order for the product to be put lawfully on the market, Article 1687 has nothing to do with the issue. It's a requirement that flows from the directive. It's the very argument the court rejected in Apposite. And then they rely again on AGCM. I will address that in reply. And then they have some complicated arguments that I simply, with respect, don't understand at 50 and following by reference to IEFA and Apposite. They are not arguments that the judge endorsed or accepted, but they do seem to drive the conclusion that there is no requirement for a prior prescription. And my simple answer is that is impossible to reconcile with what is here, the very clear language of the court's judgment. So on issue 2, we say the matter is very definitively decided in our favour. What you can't do, unfortunately, as the judge did, is duck that topic. Because if you duck the topic, you've failed to look at one of the two conditions for the medicine in question not requiring a marketing authorisation. And it would follow, and I think it is the logic of the Secretary of State's case, that if there is no prior prescription, then any sale or supply of the unauthorised medicine is in breach of the provisions of the HMR. So I think the Secretary of State would accept that any supply without a prior prescription is a contravention of the HMR. And I see him nodding. Now that, on one level, is the beginning and the end of the case. But we're here to...
Could you articulate, assuming you're right, why, in what precise way that makes the guidance unlawful? Because it fails to point out positively that you need a prior prescription.
The guidance is predicated on wholesale supply, just bare wholesale supply, being available to source the demands required to meet the policy.
Right, so you take that as a given.
And it's wrong.
You say it's unlawful.
Yeah. It's a logical predicate. If you go back to the emails my learned friend Miss Stratford showed you,
Yes, I remember.
it's absolutely plain that's what's in contemplation. And indeed, it's plain, and if you go back, I mean, some of those emails
No, I wasn't intending to take your
particularly
position.
damning.
I just wanted
Yeah, the,
Sure, that was the logic of the illegality on which you rely.
the email in question from the clinical pharmacy services, where they say all the stuff about doctors and doctors prescribing discretion is very interesting. What about our clinical responsibilities as pharmacists? What are we permitted to do? We can't see how we can lawfully wholesale source this medicine, and they're told that they can.
You're
That,
not trespassing on this track.
yes, I am, but I'm explaining why it's relevant. Anyway, so ground 3A, modification. You have two tasks with respect in relation to modification. The first task is to understand precisely what the legal test of modification is. And the difficulty in relation to that is the test is unexpanded or largely unexplained. You've got that elucidation in IEFA about a fundamental characteristic of the product. But the test, because it's not built in anything in the directive, is unclear. And if we go back to Supplementary Bundle B, tab 23, and back to the 3 bullet points I showed you in an opening, perhaps you can now better understand what I'm saying in relation to this. At page 456 of Sup B. What we know to be a modification is anything that affects the composition and thus the assessment of safety and efficacy and quality, the active ingredients, as my Lord Justice Floyd for the first bullet point. That's clearly on the wrong side of modification.
Supplementary B.
Tab 23, page 456. These are the 3 bullet points summarising the 3 targets aimed at by the manufacturing and marketing authorisation. So we know that the first bullet is beyond the pale in terms of modification. And we know, because the language of the court is all about repackaging and Aventis, that the third bullet doesn't amount to a modification. But what is unclear from the test, and up for grabs, if you like, is the question of quality. And the problem is, once you start thinking about quality, you realise it rides shotgun with questions of composition. Because if you do anything that impacts upon the quality of the medicine in question, it is no longer safe and efficacious. Indeed, it is no longer the same medicine. It's no longer the medicine that has been approved. And you go back to that passage that my Lord Justice Floyd referred me to at page 356 of the MHRA review, where they said, and we do think this is really at the heart of matters, a licensed biological product, because of its complexity, etc., such as Avastin, is not only defined by its release specifications, but also by the tightly controlled process by which it's manufactured.
Thank you. What's the page reference for that?
356 is the preceding tab. Put simply, if you, even in a sterile process, decant one of these complex biological molecules into a container with the wrong plastic, such that the biological molecule leaches into the plastic or interacts with the plastic, it is no longer the same product that was authorised.
But what I'm not clear in my mind is whether you accept that it is possible, even if only theoretically, in a super duper clean facility with highly expert people, to do this operation of decanting smaller doses into highly suitable, perfectly fine syringes. Do you say that is still a modification because, for example, the shelf life is necessarily shortened, or do you say that the modification there is always a risk of modification if it's not done properly. Which is your...
I say two things, my lady. The first is I say that the test has to be geared towards the risk of modification. Because any test that works on the basis of whether or not in any particular factual case the thing has been modified is a test utterly productive of uncertainty. It means effectively, if you successfully engage in the manufacturing process, there's no modification. If you unsuccessfully engage in the manufacturing process, there is. So the test has to be focused on risks of modification. And that's the only thing that aligns with the risk-based, public health-based focus of the directive. So that's the first thing I say. But the second thing I say is, even if there were at the outer limb the possibility of some kind of completely perfect process, it would have to result in exactly the same thing being present. It would have to have the same shelf life. It would have to have the same stability. It would have to have the same presence or relative presence of particulates, etc. If any of those things differ, it is not the same product. Not least because any of those things, if you change the shelf life, if you change the characteristics of the product in that way, that's a pretty substantial variation. And the impact of the manufacturing process, in my submission, is demonstrated by the very substantial difficulties my clients, and my learned friends' clients, have had in securing variations. Because for these products, and it is very much because of the type of product, for these products, manufacturing is an integral part to ensuring the identity of the product in question. Now, the sad thing is, none of these issues were investigated in the case law because the case law was argued by reference to packaging, etc., for the reasons I've explained. And this issue hasn't been grappled with. But we say, once you look at the question of fundamental characteristics, and you know from the MHRA report there are no stability checks, there are no checks being undertaken about contamination, etc., all the various things detailed in 353 onwards, you know the shelf life is at the very most, and that's under a special, at 90 days, probably down to 7 days because of the risks of microbial infection. That is a completely different product. It's changed its fundamental characteristics, not least because you've got to use it up in a great hurry because it's been through the compounding process. And again, to go back to the language of 356, there is a candid recognition that it's not expected that specifications for a biological drug substance filled into a syringe are the same as for the drug substance filled into a vial. Why? Due to changes that can occur during processing and storage. So the composition, the actual composition of the product will have changed as a result of these processes being applied. It is not like taking pills in blister strips and moving them. It's not even like opening the blister strips for pills and putting them into a bottle, because that doesn't affect the composition of the pill in question.
Right, it's like opening a can of tuna, because the tuna then only has, you have to keep it in the fridge, and it only keeps for a little while, whereas if it's in the can, you can keep it at ambient temperature. The tuna hasn't changed its composition, but it's a different, I'd say it's a different product.
It's done in a vacuum, so the processes of oxidation are designed to be controlled, but the evidence shows that the processes of manipulating and handling the product generate risks of particle agglomeration, etc. The problem is you're applying a process that systemically risks creating these changes, and that's the very risk the directive is meant to regulate through the manufacturing authorization process, and it's quite different to the types of risks that were being argued about in Apposite. Now, the particular difficulty...
The oddity that I'm struggling with, maybe there's no real answer to this, is that even if one operates a clean room of the kind my lady described,
Yeah.
everything's absolutely perfect in terms of decanting the vial into the syringes, repackaging them. At no stage does anyone test whether your product is actually suitable for putting in people's eyes. And supposing your product has got a particular level of particles, which is
Not my product, their product.
perfectly acceptable. Now your product, Avastin, has got a perfectly acceptable level of
Avastin's not my product.
Novartin,
No, Avastin is well known.
It's my product.
Compounded Avastin is what Mr. What?
Well, spreading Avastin has got levels of particles perfectly acceptable for cancer treatment, but which render it completely unsuitable for intraocular injection because it puts particles into the eye. And nowhere in this process is there any proper investigation of the suitability for a new indication, which is something which you have to apply for a marketing authorization.
Absolutely. There's no batch control to check that the things in question haven't.
No, that's not my lord's
No,
point.
I know. I'm making a further point.
Well,
my lord's
I
point.
want to know what you think about his point.
Completely correct. Completely correct.
So that, then that just, probably that, all that shows is that the apposite exception creates a lacuna that there's nothing anyone can do about.
But it's particularly acute in relation to manufacturing. So in relation to the general particle safety, you have the Cat and Ivan trials reviewed by NICE, and they were prepared, as the note I've handed up shows you, pursuant to a manufacturing license, so of good quality.
That's a very fact-specific
Yes.
circumstance which you might not have in another case. where
That's
something
that's the point, my lord. That's exactly the point. And do you know what? There is literally nothing new about this. This is a risk that has been known about in the system for a very long time. Indeed, it was looked at by NICE as long ago as 2010, and that is in Supplementary Bundle A, tab 13, when the very first efforts to look at whether or not it was possible to systemically use CB. And the very risks that I've been identifying were identified even then, and they have never been addressed. So page 165, key points for the discussion on the implications of appraising an unlicensed medicinal products. 3, standards for manufacturing.
Give us a second. Where are we?
Sub B,
B.
tab 13, sub A, sorry, tab, sub A, tab 13, page 165. Sure. This document is a workshop, report of findings from a workshop held at NICE on the 13th of July 2010. And the workshop was attended by a wide variety of stakeholders, including, I believe, the MHRA. And at 165, you see the problems being identified. One and 2 are about clinical risks, molecule design, etc. 3, standards for manufacturing bevacizumab for intravitreal injections, splitting vials, could be agreed to minimise the risk of but they haven't. 4, safety management and surveillance is required. Coordination role the NHS may be willing to invest in. But then over the page at 166 and following, all of the safety concerns are then further explained. Concerns were raised about the process through which intravitreal bevacizumab is manufactured. They were the absence of central organisation to oversee standards of manufacture and the potential for variation in the techniques provided. And then you've got Moorfields, who is the preeminent eye hospital in the country, which was then the source. What the document doesn't explain, and there's at the bottom the 7,000 figure I mentioned yesterday. They were producing, Royal Liverpool's producing 7,000 doses in 2010. Moorfields had a breakout of eye infections due to the poor quality of the medicines it was producing. And it no longer makes CB.
This was at a time when, is this right? When
Eylea was
Avastin
licensed.
was, sorry?
It's at the time when Eylea was licensed.
Right. When did Eylea get its license?
Oh, I'm wrong in that case. I'm told it's 2012.
I thought this was at a time when it was Avastin or nothing, because neither Eylea nor
You're right.
Lucentis.
You're right. Lucentis was licensed. My client's product was licensed. That's the point.
When was Lucentis licensed?
2007.
Yes, I see.
So once it was licensed, it created, if you like, the impetus to try
In fact,
to...
one can see that
Yeah.
on 161, because ranibizumab is Lucentis.
Yeah.
Okay, thank you.
So none of these risks are new. None of them have been addressed. And the question you have to ask is therefore whether that type of manufacturing risk is a modification or a risk of modification for the purposes of the test. And we say,
So I see your point that when in Avastin and IFA, they're talking about modification, that has to be read as a risk of modification. Otherwise, you don't know until after the stuff has been made whether it's been modified or not.
you don't apply regulation after the event. The whole point is to provide it before the risk occurs to prevent it occurring. That's the purpose of regulating manufacture. Otherwise, you just have sanctions for bad manufacture. So our case is it has to be focused on whether or not there exists a risk of the product being modified by this type of manufacturing process for a product of this complexity. And the answer to that on the evidence is only one way, yes. Now the problem we have is that the judge didn't address this question. I mean, it's one of the peculiarities of the judgment that the case law that on any analysis I'd suggest is at the heart of this case, Apposite and IEFA, in relation to the prior prescriptions issue, she finds there's no requirement for prior prescriptions. And in relation to the question of modification, she doesn't address the issue because the MHRA wasn't before the court, and she wasn't prepared to take issue with our argument that because the MHRA was saying the product was unlicensed, it must follow that it was unmodified. And the judge indicated that she found it unsatisfactory that the MHRA wasn't before the court. But then didn't say anything at all.
It must be unlicensed, it means it must be modified.
Yes.
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 So, because it was...
But she also said that questions as to safety were determined by the NICE's decision that it was safe. But you say, well, that's a different kind of safety
Absolutely.
from the kind of safety we're talking about.
As we said repeatedly to the judge below, that addresses the safety by design, the clinical trials, etc. It does not address the critical issue of whether or not the product in its manufacture and after it's been through a manufacturing process remains safe as a product. And so the judge, with respect, simply hasn't grappled with the issue of modification. And I'm afraid the plot thickens because it's barely addressed as a discrete topic in my learned friend Mr. Locke's skeleton argument. Perhaps we should turn up that next. And if one looks at his skeleton at page 97, core A, tab 4, nothing in 57 through to 63 addresses the issue. The closest one gets to it is at paragraph 61, where he says, in Apposite, the CJE ruled that if the composition remained unchanged, no new MA was needed. It follows that CB, unless subject to a change of chemical composition, cannot be an unauthorised medicine. But that's as close as you get to the engagement with the actual arguments we made, which is there is a manufacturing risk here. The manufacturing risk will result in a change in the composition of the product, and it will not be the same product. So I wait to hear what my learned friend says about the question of quality, but there's really not much to engage with either here, or for that matter in his Respondents notice.
You get something out of 62.
Well, that's just a placeholder, my lord, for the Respondents notice, which I was going to show you next, because he says it follows that the MHRA must have been incorrect in finding it to be an unlicensed medicine. A stance the MHRA has not resiled from. The MHRA stance is it is an unlicensed medicine, but that it may be used with a prescription. I'll come on to in a second what its position is as to modification. So it hasn't resolved from the stance that it's an unlicensed medicine. The only other document that sheds any light on this in my submission is the Respondents' Notice. And most of the Respondents' Notice, which you'll find in tab 3, page 74 and following, it's simply directed to a bare argument that the product is a licensed medicine that can be supplied without a prescription to a doctor. The closest again one gets it was at Roman 5, where they say apposite means it's not a modification. So the question of modification hasn't been addressed by Mr. Locke any more than it has been by the judge. And then when one gets to the MHRA's skeleton argument, the topic of modification is, so far as I can see it, entirely unaddressed in the MHRA skeleton. The MHRA skeleton is all about placing on the market.
Remind me where we find the MRHAs.
Tab 6 of this same bundle.
Yes, sorry, you were confusing me. You mean the Secretary of State?
Secretary of State. Yeah, sorry, it's the Secretary of State. Acting with many hats. SPS, MHRA, Pharmaceutical Quality Assurance Committee, the whole shooting match. Well, look at the structure of the skeleton, my lord. There's a section on the role of the Secretary of State. There's no paragraphs. Placing on the market, they say, is a topic one has to look at. Nothing in here is about modification. It's all about what the test is for placing on the market. Then you go through the grounds sequentially. They explain why they're not answering ground 1. They're with us on ground 2. Ground 3A, there's nothing on ground 3A. Just goes straight into effectively looking at the legality of modes 2 to 4 for ground 3B. So, again, I wait to hear what my learned friend says about this issue of principle, about whether or not changes risked by manufacturing processes that might affect the basic integrity of the fundamental characteristics of the product, its shelf life, its risks that it brings of microbial infections. The whole reason why the RPS document said no more than 7 days, because anything more than 7 days is an unacceptable...
We have had these points a number of times before.
I'm sorry. So, there we have it. You have my case, and I'll address whatever's said in relation to modification in reply. That then takes us to placing on the market. Now, the real peculiarity of all of this is that the judge's analysis...
This is ground 3B, is it?
3B. The judge's analysis in relation to placing on the market is entirely divorced from apposite, because the judge has concluded no requirement for prior prescriptions. She's accepted that there is a modification, effectively, because of the MHRA stance. And yet, notwithstanding that, she concludes that for each of the modes, there is no placing on the market. So let's take them in logical order. Let's start with the outlier, if you like, mode 4, commercial supply. The circumstance which we're initially directed on the judge's analysis is mode 4 supply without a prescription. Now, I think mode 4 supply without a prescription, the Secretary of State and us are in agreement in relation to. He accepts that mode 4 entails a placing on the market, and that will be unlawful without a prior prescription. So the judge's reasoning in relation to mode 4 must be wrong, but let's, on that analysis, let's look at what the judge says in relation to mode 4. The reasons are at page 194 of tab 9.
Sorry, I have it loose. If you paragraph numbers, if I may.
Yes, paragraphs 232 to 235. And the principal reasoning is this mature market argument. There's a mature market, there are third-party compounders, and therefore even if it's a market built on repeated breaches of EU law, as the claimants assert, I'm not persuaded that an NHS trust will be necessarily in breach of EU law and taking advantage of it. Well, with respect, first of all, the evidence doesn't show that there is a market based upon repeated breaches.
Sorry, this is complete ignorance on my part. Why? I didn't understand when I read the judgments. I never got to the bottom of what the significance of there being a mature market was said to be. You say there isn't any, but what is the mature market point?
The argument was Mr. Locke's argument. Effectively, it was my clients should be free to go into the market and buy this widely available product, just as any private clinic should be free to buy.
Is it an argument that because they are not breaking the law by buying it,
That's right.
and there it is, apparently safe, so that's fine?
Well,
Is that the argument?
yes, and the simple answer is the pharmacists are breaking their pharmacist duties by procuring it, and you are breaching the HMR by holding it for the purposes of onward supply.
What's the HMR?
The human medicines regulations, the provisions of Regulation 46 and following that I took you through yesterday. So whether or not the buyer has breached the law is not the end of the seller has breached the law is not the end of the equation. The equation also encompasses what the buyer does, and the HMR make that absolutely plain. A pharmacist couldn't lawfully go and buy that medicine, and that's the end of the inquiry. It's also factually wrong to say that there was a mature market to supply CB for wet AMD that we had connived in the creation of, because it was completely impossible for us to ascertain whether or not any supplies of wet AMD were or were not either properly supplied as specials, as they could be, or were not lawfully made as small-scale, ad hoc retail supplies under 310. And the evidence is very clear that when it became apparent that other NHS hospitals were planning to source bulk supply in this way, we brought judicial review proceedings. And that culminated in the SHIP judicial review and the withdrawal of the policy. So the judge's reasoning in relation to that, with respect, doesn't begin to pass muster. And of course, if there is a modification, as well as the absence of a prior prescription, that is the end of the matter. You also have my further points, the new points, the points I readily accept and new, responsive, which is this is avowedly wholesale supply. Paragraph 44 of my learned friend's skeleton argument. And wholesale dealing in relation to unlicensed medicines is impermissible.
This whole distinction between unlicensed and off-label, is that something we need to worry about?
Off-label's only relevant when you come to the question of use and administration. The notion of off-label has no meaning whatsoever, no utility when you're looking at questions of wholesale supply. It doesn't mean anything at that stage. It's not off-label because it's simply being provided to a doctor. The doctor is then going to decide how it's used. So you can't have an off-label medicine at the wholesale level of supply. It doesn't make any sense.
It's only referring to how the doctor chooses to use
Absolutely. At use, at the point of use.
Presumably, if you're wholesaling it, you, to some extent, have to relabel it, otherwise nobody knows what it is.
Absolutely. And you've seen, the minute you have a label that doesn't conform.
You change the label.
Exactly, and you've got a new product. And you've seen the provisions in the Schedule 26 that shows the label that you must apply immediately as the compounder if you're relying on the compounding exception, including the name of the patient, etc. If you're wholesaling those products, you're wholesaling something with a get-up that's completely different to the thing with the marketing authorization. So wholesale supply under Mode 4 is simply impossible. And the analysis in our submission is no different in Mode 3, because the terms of the human medicines regulations make it absolutely plain that the operation of the regulations is entirely blind to whether or not the party supplying or the party supplied is a part of the NHS or not. And it makes that absolutely plain in the definition of business. There is no special get-out for the National Health Service. And even if EU law permitted one, it's not one that's been seized by the legislator here. So mode 3 fails because there's no prior prescription, there is a modification, and there's wholesale dealing. Can't fall back on Article 3.1 in those circumstances, even though they haven't attempted to do so, because Article 3.1, as implemented in the UK, does not permit wholesale dealing. Compare and contrast specials, where you are permitted to do wholesale dealing in relation to specials. That's national discretion. The national law in question has not permitted any form of wholesale dealing in relation to Section 3.1 compounded medicines. You simply can't do it.
Article 3.
Article 3.1. So that's mode.
Remind me where that, what the national legislation is that limits the implementation to exclude wholesale.
Yes, my lady. If you take up,
Well, don't need to show it to me because I'm sure we've already seen it, but just remind me what it is.
it's regulation. Let me get the. Should know them by heart, but sadly I don't. Sadly. It's regulation 18 and 19, read with, in particular, regulation 43.5. Do you remember 43.5, which is the provision that says the licence holder cannot supply a medicinal product unless there's a marketing authorisation for the product and the sale or supply or offer for sale or supply is in accordance with the authorisation. And I compared and contrasted that, which basically bans dealing in unlicensed medicines, with the provisions in Article 167, which is the provisions relating to specials, and there was a provision at 167.8 that permits, in certain narrow circumstances, wholesale dealing in specials. So mode 3 is impossible. Mode 2, our first answer is, it's all hypothetical. We know that. Why are we looking at mode 2? Has nothing to do with how this policy is going to be implemented, because none of these hospitals have the capacity to implement. But if you have to go through the apposite analysis, a prior prescription is required, and they say, no, it's not. There is a modification, and therefore you are forced necessarily out of the apposite exception into Article 3.1, which is available for use in National Health Service hospitals, as long as you comply with it. What does that mean? It means you comply with the Section 10.1a gateway, which again reinforces prior prescription. It means that you comply with all of the policies that you have to in the RPS document, and it means that you comply with the Secretary of State's guidance about what is on the right or wrong side of Section 10.1a. It comes back to the question of the difference between preparation and manufacture, and it comes back to the guidance from the Secretary of State that what Section 10.1a is designed to facilitate or permit is small-scale production. Large-scale production is not preparation, it's manufacture. That requires a manufacturer's license. So even if Section 3, Article 3.1 or Section 10.1a were available, it does not permit the sort of bulk supply that this policy scheme requires for implementation. And that's what we say in relation to that. What does the judge say in relation to Mode 2? I should have said in relation to Mode 3, she says it stands and falls with what she said about Mode 2 and Mode 4. The principal argument advanced by the judge is, well, the supply is as between the pharmacy and the doctor, and that's within the same entity, and therefore there can't be a placing on the market. But the simple answer to that is that that's not the relevant point of inquiry. The relevant point of inquiry is the supply by the hospital to the patient. And we're back to you can't make it in a shed, supply it directly and claim that the Medicines Act and the directive doesn't apply to you. It applies to any placings on the on the market, whether it's straightforward, straight up, first up retail supply, or whether it's predicated on wholesale plot supply before retail supply. They're all
So
called.
supply to the patient is retail supply, but that is also a placing on the market.
Absolutely. That's the point. And beyond that argument, the judge's main concern in this context seems to have been the Hecht industrial argument, and as we know, that argument has gone. And whatever else is envisaged by Mode 2, it certainly meets the test in Hecht about serial production in batches. Do you remember the language there? And that argument's no longer maintained, so it is industrial supply, it is a medicinal product, it is being, if you like, made in-house, but it's being supplied to a patient. And the NHS has no free pass to manufacture whatever medicines it sees fit outside the scope of the directive. If it chooses to manufacture medicines, it's got to be licensed in the way that the directive and the domestic regulations require. That's why, go back to the sheet I handed up, when NHS hospitals make specials for their own use, they get specials licenses. So that's Royal Liverpool making CB for the treatment of its own patients. It has a specials license, or whoever the hospital is. Why does it have to have a specials license? Because if it doesn't have a specials license, and it's not complying with the terms of Article 3.1, it will be placing the product in question on the market by supplying it to the patient. That's why you have to have, even for your own supply.
That makes a logical, sort of neat, logical sense. I still find it hard to see where you find it in the words of the directive. Placed on the market is a very odd language to describe the supply by.
That is EU jargon for placing on the market means sale or supply, or as the court has said, first.
All right, but if I was, is it supply? If I inject you with a medicinal product, am I supplying? Am I?
Well, that's you are supplying it and then administering it. Otherwise, there would be no supply ever in a hospital, and that's clearly not.
Well, I can see that for the purpose of domestic law about supply, but what about, where do you get the equation of placed on the market with sale or supply?
Well, first of all, that's the Secretary of State's case.
Well, I dare say, but where do you get it? Where do
That's
you?
the language that they use to
Well,
translate.
I dare say, where do you and he get it from the directive or from the case law?
It's a synonym for placing on the market.
Well, so you say, but show me why you say that.
What?
Used in the HMRs.
It's used in the HMRs. That's why I say it's the synonym. It's what our legislator has said is equivalent.
Well,
I can't take it beyond that, my lord.
well, all right, but don't patronise. Just give me the answer. The answer is, as I understand it, that whether or not that is what you can find anything in EU law saying that, in implementing that in the MHR, we have used the language of sale or supply. It's a perfectly good answer, but you want to give it to me rather than.
I'm so sorry, my lord. I wasn't intending to be disrespectful in the least. I'm just saying the answer is that's how we've transposed.
This is all very familiar to you, but it's not all very familiar to us.
I really apologise, my lord. I suppose it's also further demonstrated by some of the implementing provisions in the HMR that perhaps I should take you back to, just very, very briefly. I did make the point when opening the definitions that the term sale or supply, unhelpfully itself, isn't defined.
Yeah, I've got no problem with it.
Yeah.
The concept as a matter of domestic law. Now I've thought it through,
But-
that you supply a drug when you administer it. Well, the missing piece, which for me I think you've satisfactorily supplied, was that you told us yesterday, but I needed to be reminded, that the concept of placed on the market in Article 6
Yeah,
has been transposed into domestic law by the language of sale or supply.
that's right.
And that's all I need, and I will find the reference, no doubt, when I
If you look
my
at-
notes from yesterday.
Regulation 46, page 409 of Authorities Bundle B. Regulation 46 is what transposes the prohibition on placing on the market without...
And that uses the language of sale or
It
supply.
says may not sale or supply throughout all the sections.
Okay, we're there, thank you. I'm sorry if I was
Yes, the Secretary of State agrees.
dirty, but we've got there.
and-
That's
I was just going to make this further point, my lord, that at 402 in the definitions, there are all kinds of definitions of what it means to distribute or supply by way of wholesale dealing, etc. And again, those provisions all talk in the language of sale or supply. And they're intended to transpose the same obligations in relation to manufacturing licences, wholesale dealing licences. So that throughout the HMR, whenever you're approaching one of the relevant licensing obligations, whether it's marketing authorisation, manufacturing authorisation, wholesale dealing licence, the language is sale or supply.
But you don't need a licence. There's no such thing as a retail supply licence, is there?
No, there
Right,
isn't.
but what the relevance of it being a placing on the market, even though it's a retail supply, is not that you need a special licence to do so. It's that you cannot do it if the drug is not covered by a marketing authorisation.
Correct, my lady. Correct. Retail supply is an area regulated by domestic law. All the EU law says is that prescription-only medicines can only be supplied by prescriptions, and that effectively you have got three categories: pharmacy medicines and general sales medicines. And who's entitled to sell pharmacy medicines or general sale medicines is up to national law to decide. That is all I had proposed to say in relation to the placing on the market arguments. Unless there's
What
a,
about mode 1?
that's for my learned friend Miss Stratford, because the arguments at 3A to 3B address only modes 2 to 4. As I said, we accept mode 1 is use and administration, and that entails a different legal analysis.
Thank you very much, Mr. Delavan.
My lords, my lady, ground 3D is our broad submission that the policy unlawfully undermines the scheme of the directive. And we say it takes what's supposed to be an exception, the small-scale supply of unlicensed products, and turns it into the rule. And we say, as you've seen in our skeleton, that a public body may not, to save costs, procure and promote the invariable and systematic use of bevacizumab to treat wet AMD where there's a licensed alternative. These submissions were ground 2 below. They were dealt with only very shortly in the judgment, and I don't need to go back to it unless you want me to, particularly given the hour, but it's paragraphs 240 to 246. But we do say the judgment has startling implications. In particular, it is one of the places in this case, this appeal, where it's apparent that the issues raised by the policy have wider implications beyond bevacizumab. And that's because the judgment arguably opens the door to mass supply of unlicensed and indeed and now also off-label medicines outside the marketing authorisation regime, simply whenever NHS bodies consider it desirable. And going back to Lord Justice Floyd, my Lord Justice Floyd's exchanges with Mr. Delamere earlier this afternoon, there may be some studies available here. We know we've got what are known as the CAT and the Ivan studies, and certain materials looking at other international studies available, which will look at the safety and efficacy of compounded bevacizumab. But that will not be the case in many other cases. And we do say that the wider implications of the judgment in this case do need to be borne in mind. Now, like ground 1, on which I addressed the court yesterday, these submissions are ones that apply equally to Mode 1, original values, to answer my lady's point. That's what we say in ground 4, which we dealt with separately in our grounds and our skeleton, since, as Mr. Delamere has just explained, ground 3 was all about compounded bevacizumab. But happily, all of the substantive points that we make are the same under 3D and 3E. All of the points come in equivalently substantively for ground 4. So I'm not going to need to address those separately. I'm grateful. Conscious of the time, what I've done, I hope it will assist, is to reduce our submissions to a note. In fact, well, 2 notes, in fact. One folds into the other. And if I could just hand those up.
Thank you, that's very helpful.
Just while that's happening, there's one loose end from yesterday. My Lord Justice Floyd asked about the footnote to the report which we looked at, the report to the CCGs, going back a long time. We have looked at that. Frankly, it doesn't assist. I can hand up copies of it if you would like, but it was produced in, it's a 2014 document, so it's pretty old in terms of this case and the consideration of compounded bevacizumab. It doesn't consider aflibercept, my client's product, at all. It's cited, it's a footnote saying it's going to explain where the £49 million figure comes from. It doesn't mention the 49 million figure in it. It's actually got a figure of 70 million cost savings over 5 years.
Unless anybody else
So I really don't think it assists. I just, for completeness, I wanted to mention it, so we haven't forgotten about it. I'm grateful. So, what I do in looking at the note of submissions on ground 3D/4 and ground 3E, it's really 3E/4 as well. The structure is first to address the legal basis for the submission, and then to say, address the ways in which the policy undermined the EU medicines regime, we say. And as we explain in our skeleton, there are different ways of packaging this point, the legal basis for our submission, but they all get you to the same place, we say, and it doesn't matter which one you use. The end result is that you can't have a policy that recommends systematic supply and so thwarts, we say, the aims and provisions of the EU system for regulating medicines. And our 3 legal hooks are first the directive itself, that's in a way the simplest analysis, just to say that the provisions of the directive must be interpreted to preclude a systematic supply of bevacizumab to treat wet AMD, because otherwise the directive's fundamental aims would be thwarted. And that builds on everything that Mr. Delamere has been submitting, and I don't need to say any more about it. The second legal basis for the submission is to point to Article 4.3 of the Treaty on the European Union, that's a well-known principle of sincere cooperation, and we have a short quotation, which I don't think is controversial, from the well-known EU John Temple Lang, articulating that principle, and in particular the duty to avoid any action which interferes with the way in which the legal system of the EU is supposed to work. That's not saying anything surprising, and again, I don't think I need to say any more about it. Now, I had intended to take a little bit more time on the CTRS case, but in the interests of speed, what I've done in the note is to reduce our submissions on CTRS to writing. Now, of course, that case I fully accept concerned a different part of the medicines regime, the protection for orphan medicinal products. And that was why the judge dismissed out of hand its relevance. That's paragraph 232 of the judgment. But we do maintain our submission that it provides an analogy, albeit from another part of the medicines regime, but still from the medicines regime, and shows that a decisional policy will be unlawful under EU law if it engenders a situation which is likely to lead to the circumvention of important aspects of the medicines regime. Now, we do have to recognise that these broader submissions and ways of looking at the points have not so far either been squarely put to, and certainly not taken up by, the Court of Justice, the Luxembourg Court, including in the 3 cases that have considered bevacizumab. But I think I can put AGCM to one side because, as Mr. Delamere has said, that really is a competition law case. But IEFA and Avastin, I have to recognise the court didn't, even notwithstanding that the point wasn't perhaps put in the way that I'm putting it, the court didn't of its own motion take up the point. But I would say 2 things about IEFA, just building on what Mr. Delamere has already said. First, and the court's seen this, it didn't concern a preference policy of the sort that we're considering here. It was all about reimbursement. And we do submit that's a material difference. Second, the court did there stress that the directive controls the entire chain of distribution of medicinal products. We say yes, and the court points out it does so even when member states are exercising reserved powers concerning their national health services. That's paragraphs 50 to 51, which the court saw earlier this afternoon. So to that limited extent, and I accept it's a limited extent, we do say that there's some support in IEFA for these broader submissions. But fundamentally, we say that the point simply hasn't been put in the way that we now develop it, or in relation to a policy of this nature. So, as I say, CTRS, we've summarised in the note. In the first section, we explain its relevance and make the points that I've just made about IEFA. Then come on at 2b to outline the facts and the reasoning of the Court of Justice. And again, in the interest of time, I think the points that we derive from it are summarised at little d of my note on page 3. So we say that CTRS shows that EU law will not permit, even in an area where the legislation is not directly engaged, and that was one of the points that the court made expressly in CTRS, the court will not permit decisions or policies that circumvent the EU medicines regime. And in fact, we say this case is a fortiori CTRS because in that case, the statements in question were found to be liable to encourage off-label prescribing. That's paragraph 89 of the judgment in CTRS. Whereas we say this policy is deliberately designed to prefer unlicensed, or as the CCGs would prefer to characterise it, off-label prescribing. So, yes, as the judge said, in CTRS what was being circumvented were the incentives granted to companies who develop products to treat rare diseases, the particular orphan market exclusivity. But we say here, equally, what's being circumvented are the controls put in place by the more general EU medicines regime, all of the controls which Mr. de la Mare has taken the court to in such detail, how a medicine comes to be placed on the market, the pharmacovigilance and other requirements that come with that, as well as indeed everything that the EU medicines regime does to encourage incentives for innovation in the pharmaceutical field. So we do say that even if the policy is fulfilled via modes 1 or 2, which of course, going back to our ground 1, we say it was not designed to be, but even if it's fulfilled via modes 1 or 2, it does represent a systematic and market-altering intervention and occupies a space which we say is intended to be regulated under the medicines regime. Coming on to the ways in which we say the policy undermines that regime, and I've given the references to the passages in our skeleton there, but to trace through it quickly, the first and fundamental point is that by preferring an unlicensed medicine, the policy, we say, undermines, or to use the CTRS language, it circumvents the primacy given to patient safety. And this, again, is one of the parts of the case where the intervention of the Secretary of State and the work that the MHRA has done in its review has assisted in my respectful submission, because there is recognition there that there are safety and other issues that arise from the compounding of bevacizumab. Now, the judge's short answer to this, and this is what the CCGs adopt in their skeleton, is to say, well, now we've got the NICE guideline of January 2018. We can see that it's all fine. There are no safety issues arising. Now, even putting aside the fact that the NICE guideline came out obviously after the policy, but even ignoring that wrinkle, we say, of course, that the guideline was never focusing on any of the quality issues, which we say specifically arise from the compounding process itself. It was looking at the safety and efficacy of the bevacizumab formulation as evidenced in the published trial data that's available.
That's the difference between safety by design and risk of modification that we've been talking about.
Exactly, my lady, I'm grateful. My lady, this is where the second note, I hope, will also assist with speed, because what we've done there, and this to some extent overlaps with some of what Mr. de la Mare was showing the court earlier, but we have sought to collect together in this note the points where we say the Secretary of State's materials support the propositions that we put forward on quality risks, and then turning over to page 5 of the note, risks from lack of regulatory scrutiny, and page 6, risks from lack of pharmacovigilance.
Sorry, I've got lots. So which pages are you referring to? Oh, I see.
On my separate note, it should have
Yes, no, I've got them.
middle.
No, I've got them, sorry. I was looking at the wrong category of headings. Thank you, Liam.
So we put forward in each case a proposition, and then we quote from the MHRA materials the points that we say make good those propositions, and I don't propose to take the court through those if that's acceptable.
No, that's extremely useful. Thank you.
I'm grateful. Just building on what the MHRA say about regulatory risks, so this is section 2 of the note, there is also the point that we flag in our skeleton, paragraph 62E, that it's, to say the least, very unclear how and whether there will be proper regulatory scrutiny of the compounding processes, in particular in relation to mode 4. And Mr. de la Mare did make this point earlier, but it was there was so much ground to cover. I just wanted to emphasise that in relation to mode 4 and commercial compounding, we do point out in our skeleton that there seems to us to be a particular regulatory black hole. The CQC has confirmed it has no jurisdiction. This is addressed, that's addressed in we are back to the new evidence, Mr. Kelly's witness statement, paragraph 36B. So that's
You can probably
unagreed.
get there, can't you, without actually relying on the evidence as such at all, because it's in a sense evidence of absence, isn't it?
Well, yes. We would say we've got even better than evidence of absence, because we've actually got confirmation from the CQC itself, as Mr. Kelly explains. But be that as it may, and we've also got the MHRA, we know their competence is confined to specials manufacture and compliance with directive exemptions, including Article 3. So we submit, got a real lacuna there in relation to mode 4. Then moving on, we outlined in our skeleton and summarise in this note the respects. So if you give our skeleton notes, you'll notice at paragraph 63, the respects in which the policy fails properly to respect the different roles of the different regulatory bodies. And that's one of the ways, so that's the second way that we say it undermines the EU medicines regime. Now, again, here I have to be candid and accept that the MHRA, or the Secretary of State, in his skeleton, has not taken up these concerns with a carrying call to keep off his patch. But we do maintain those submissions as a matter of principle. And I would point out that as part of the MHRA review, the Commission on Human Medicines, that was one of the bodies involved in the review, did stress that the first instance judgment in this case did not differentiate between the primary roles of the MHRA in the evaluation of safety, quality and efficacy on the one hand, and the role of NICE in the evaluation of cost effectiveness of treatments on the other hand. And that document, I can either give you that for your note, or we can go to it. It's at Annex 8 to the report, so it's at Supplementary Bundle B, tab 22, page 453, at paragraph 4.1.4. The second point I wanted to stress here is about the ABPI case. Because the judgment of Mrs. Justice Whipple placed considerable emphasis on that case as an example of the Court of Justice recognising that national authorities do have a role in assessing clinical effectiveness, here clinical effectiveness of what she called Avastin at this point in her judgment. That's paragraph 144, little 4. And that led her to conclude that there was support for a policy preferring unlicensed products on grounds of cost in the ABPI case. We submit quite simply that that's reading far too much into that case. The case is at Authorities B, tab 19, but again, I wasn't proposing to go to it. It concerned, as the court may know, an NHS prescribing incentive scheme to encourage the selection of cheaper alternatives where there was a range of products that could each equally well treat a medical condition. But the simple point is that all of the alternatives being considered there were all authorised. They were all being used within the terms of their marketing authorisation. That case has nothing to say, therefore, we say, about our current policy, which entails encouraging the use of either an unlicensed medicine or, as the CCGs would have it, routine off-label use of a product. My third point is that there is a clutch of cases that the respondents rely on to show that NICE and the CCGs generally have an important role to play in deciding on allocation of funds for public health spending. We say again that misses the point. None of those cases concerned unlicensed medicines or systematic orders for off-label medicines, and we say they really don't assist. So, moving on, I'm now at little c, towards the bottom of page 4 of the note, tracking skeleton paragraph 64, where we make the point that the policy undermines the careful incentives built into the EU medicines regime to encourage innovation. And we do stress this point. The court has heard already today about the efforts that my client, Bayer, have been making and continue to make to, over a number of years, to be able to market a pre-filled syringe. There's evidence about that
Is that a pre-filled syringe for ocular use or for cancer?
Yes, my lady. So at the moment, Eylea for intravitreal
Yes,
use
of course, sorry.
is supplied in a vial and drawn up by the doctor for administration in the clinic.
Yes, I think we've heard, haven't we, that Lucentis have eventually got there.
Indeed.
I omitted to ask Mr. Delamere for where the evidence was about that. I dare say it's not controversial, but you've helpfully given us the evidence on yours.
Yes.
I'll supply.
Thank you.
The reason why ours is perhaps striking and interesting is that we're still not quite there. So it just shows, we say it shows how difficult it is, even for us, who hold the marketing authorisation for this very product, to do this sufficiently carefully and well in order to be able to market that pre-filled syringe. If the CCGs are right, then there's no incentive whatsoever.
Does the vial that you sell, has that got more than one dose in it?
No, my lady. It has more than is needed for an
Yes.
individual injection, because the syringe will be overfilled, in order to draw it up properly, but no, it's made clear in the SMPC that it's only for one injection. But our simple point is, why are we, where's the incentive for us to invest in doing this properly with all of the necessary safety and quality controls if the CCGs are right and it can be done without any of these controls being applied? Now, the respondents' answer to this point in their skeleton is to say, well, this is all about profits and there's no evidence that Bayer or indeed Novartis will operate at a loss if the policy is upheld. And the implication, pretty thinly veiled, is that pharmaceutical company profits are not in the public interest. Well, putting that interesting political debate to one side, at the moment, at least for now, we do not have a nationalised system of medicines research and development. We have a system which relies on, is fundamentally dependent on there being sufficient incentives for companies to invest in what's well known to be a very risky area of research and development. And we say there's nothing wrong, therefore, at all. And indeed, it's an essential part of the system that we should be able to get proper rewards for the investment made. Our last 2 points, the harmonising aim of the directive and full information to patients, I think are dealt with adequately in our skeleton, and you've got the references there. That brings me finally and very shortly to ground 3E. It concerns the GMC's guidance and the way in which the judge interpreted it. And the judge found at paragraphs 151 to 152 and 219 that the GMC guidance doesn't preclude the doctor from choosing an unlicensed or off-label product for cost reasons alone. And we disagree with that interpretation for reasons that we explain in our skeleton at paragraph 68. And that's just a straightforward argument about how the guidance should properly be read. We do submit that, properly understood, it limits the circumstances in which it's appropriate to prefer an unlicensed or off-label treatment when a licensed one is available to situations of medical need. And in our submission, it's quite clear that that's what the GMC guidance is concerned with and is talking about. Now, particularly at this point in the hearing, I wasn't going to take up time developing that submission, not least because it's clear that this guidance, like so much of the guidance that exists in this field, will be overtaken by this court's judgment. For your note, we do set out our analysis, and I've given you the reference in the hand-up, in a summary note that we handed up at first instance. But the reality is that all of this guidance is going to be looked at again in light of the court's judgment. Nonetheless, we do urge the points made in our skeleton, and that includes the point, finally, that the judge was wrong to accept that because a doctor would not necessarily be acting unlawfully in breaching professional guidance, then a policy of a public body that systematically leads to doctors acting in breach of that guidance is not itself unlawful. And we say with respect, that seems wrong to us. At the very least, the fact that the policy makes recommendations contrary to GMC guidance must be a relevant consideration to which the CCGs failed to have regard. And failure to have regard to relevant considerations was one of the ways which we framed our original grounds in this judicial review. We all know, and I don't think this is in my hand up, for example, the buyer grounds at paragraph 5b, which is at core bundle B at 17b, page 513. I'm very grateful. I've been handed very helpfully the references to where it says in the evidence that Lucentis is in a pre-filled syringe. So.
Oh yes, it wasn't so much that, it was Mr. Delamere's point that it had taken a huge regulatory effort to get to that stage. Sorry if I haven't made myself clear.
I'm not quite sure what it says.
Frankly, it's not a point I would have followed up, except that you helpfully referred us to the equivalent evidence about ILEA, and I just thought it would be neat to have the evidence about both, if it exists. It should be a matter to be dealt with tomorrow if it's worth it.
I'm grateful.
Well, I'll ask Mr. Dillamar, if you're in a position to tell me now, and maybe you're not. You did mention to us, I think, on a couple of occasions that there had been a big regulatory effort to get.
Yes. That's my understanding.
I wonder if it's based on some passage in the evidence or just on your instructions.
I honestly can't recall whether it's documented in the evidence. That is the candid answer, my lord. I
Fair
will
enough.
go and check.
If there is anything evidenced, we have the reference tomorrow.
Yes.
If there isn't, I don't suppose it's
But
controversial. But just so that I know.
All I would say in addition is all the problems that Bayer have documented they've had to go through are identical to the problems that we've had to go
I
through.
dare say, but my point
I'll
was
look
simply
at it.
about whether there's a place in the evidence that says so.
I'll reduce it to a note. I'm very sorry about that.
Thank you. Right, then, I think normally I would say, I'm sorry, so sorry, Mr. Strafford,
No, you're absolutely
I understood correctly
My
that you got to the end.
anticipated correctly.
Normally I would say, let's start again tomorrow, but if time is going to be tight, and if there's a short introductory observation of some kind you want to make, Mr. Locke, we won't stop you.
Well, my lord, I'm in your lordship's hands. I'm quite happy to do 10 minutes now and start, or I can start tomorrow morning. It's entirely up to you.
We don't feel strongly either way, but there's something to be said for having a clean start, as long as you're going to be comfortable that 10 minutes here and there isn't going to matter for you finishing in your estimate. If it is, take advantage of them.
My lord, I have reduced a certain amount of what I want to say to writing. I intend to be reasonably focused. I see the case in a relatively straightforward and simple way in comparison to the complexities that have been presented to you. And I hope, therefore, that my estimate of a day might be not entirely taken up. And so
Well, very good. Well,
on notice that he may well be asked to rise to his feet later on tomorrow afternoon.
If we discuss this any further, we'll use up the 10 minutes anyway.
But no, I'm not
No,
concerned.
well, that's fine. Let's have a clean start tomorrow at 10:30.
Nicholas.
Oh, yes, I'm so sorry.
Yeah, it's going to
Just one moment. Sir. Yes, I'm sorry. Yes. Well, my lady can explain her concern.
The transcript is going to be extremely useful, I think, for us, and it would be great if somebody could check that where the transcriber has written Article 42 and where she's written Article 42,
Yes.
40 in brackets 2, that those are correctly transcribed.
I don't think I referred to Article 42. You need to refer to Article 42.
Well, perhaps someone, it's quite unfair for the transcriber to be expected to know which is which.
So,
So
of course, we'll
if
check
she
it.
could just be given any guidance.
No,
If the answer is every reference to 42 is 40.2, that'll make it easy
I
for
can't
her.
even remember what was in Article 42.
Lord, before I finally rise, I'm not offering to give you any homework, but can I tell you what I will be referring to first, in case you have the opportunity to do any pre-reading? At tab 19 of supplementary bundle A is the NICE report, and at tab tab 20 is the summary of what is a very, very substantial report that was before the judge below, and we didn't understand we needed to put it entirely in. I may have to bring copies tomorrow in the light of the way the submissions have developed. But essentially, tab 20 is the summary, and the clinical effectiveness issues are at page 318, and in particular footnote 2.
So what are you
I'm
discreetly
inviting
asking
you
us to do
I'm
to
inviting you to
refresh
glance
our
at
memories of,
refresh your memories.
of which passages precisely?
In particular, my lord, my lady, 318, 317 and 318.
Just those 2 pages?
Just those 2 pages, though I think in order to make any sense, you'll have to look at the structure of it beforehand.
Yes.
But in particular, my lord and my lady, it may be helpful to look at the following pages of tab 19, pages 222, 232 and 285.
Sorry, just give those references again.
222,
Yep.
232
Yep.
and 285. And in essence, the submission I'll be making tomorrow, and I'll have to go through this in a little more detail, is this. NICE was concerned with whether it was safe for the NHS to use CB, and went through an exhaustive examination of the data, not just in respect of trials, but in respect of usage. And all of the points that were put about the potential risks and difficulties in compounding mirikizumab were put to NICE on behalf of the drug companies that didn't agree with the recommendation. And when you go through what tab 19 are extracts of the full 250-page report, which are in a question and answer form, where essentially what's happened is that the drug companies have set out their concerns, their questions, their claims that it's not safe, and NICE have responded. And when you have the opportunity of reading that, you'll be able to see that all of the concerns that this is just trial data, or there's problems of manufacture, have been exhaustively considered by NICE, and therefore that will fund the submission which I'm going to start tomorrow, which is that it was entirely rational for the CCGs to have reached the view that it was safe to promote a policy for CB for being used as stage 1. And I hope that's helpful.
Thank you. Right. 10:30. Thank you.
Bye.